I know people are still logging in, but we're going to get started. Okay. So thank you. Good evening, everyone. Thanks for joining us. My name is Sean Rose. I'm the executive director here at Gift Planning at Stony Brook. It's a pleasure to welcome you. As I said earlier, we have almost 120 people expected to join us on this beautiful June evening, which is truly remarkable. So thanks for being here. Speaks to the seriousness of which this community and I think all of us sort of approach planning for the people and causes that matter most to us. So we're grateful you're here. Just a quick background in the Office of Gift Planning, where I work with my colleagues Deborah and Lindsay. We work with donors to think beyond simple written check, to consider a full range of assets available to them other than cash. Other assets like appreciated stock, investments, real estates, and life insurance are often overlooked as opportunities, yet they can be used to create larger, more meaningful gifts than many people ever imagined possible. Sometimes that happens during a donor's lifetime. It also sometimes happens through a carefully considered estate plan. With gifts from a will or retirement plan, donors can leave even bigger, more impactful gifts. And often, most often lately, through a combination of lifetime and gifts that come through an estate, people achieve extraordinary things that help Stony Brook educate future leaders, discover breakthroughs, and provide medical care to those that need it most. The gift planning team's mission is straightforward: to help people like all of you take care of your family while supporting the parts of Stony Brook that have been most meaningful to your lives. Um, and actually, as part of that, because these gifts are so thoughtful and with such thoughtful planning, we appreciate them so much. We have a special community called the John S. Toll Legacy Society. It's for people who have included us in their estate plans through beneficiary designations or with life income gifts. A gift where you make and receive payments for life. You make a gift and then you receive payments for life. But it's our way of saying thank you for these future gifts now, because you will make a profound difference no matter the size. And members often tell us that joining the Legacy Society gives them a sense of connection, purpose, and continuity, and knowing that their lives will live on through the work that Stony Brook does for generations to come. So, one final note before I introduce our speaker. On Friday, June 5th, this Friday, we'll be hosting the next session in our Southampton Dialogue series, Healthy Aging, Living Your Best Life. It will take place at Chancellor's Hall at Stony Brook, Southampton, with health screenings from 11:30 to 12:30, a reception at noon, and the dialogue beginning at 12:30. Dr. William Wertheim will lead a rich conversation with three of Stony Brook's leading experts in aging, cognition, and preventive health. And we hope to see many of you there. My colleague, is going to share in the chat the link where you can register. But if you have any questions, either about that or anything else tonight, please contact us at gift.planning. So gift like I give away, gift.planning@stonybrook.edu. Okay. Now it's my honor to introduce our speaker. Our guest this evening brings deep roots in the community and decades of experience in the areas that matter most to the families we serve. Lawrence Eric Davidow is the managing partner of Davidow, Siegel and Stern LP, a Long Island law firm founded by his grandfather in 1913, which I have to believe makes it one of the oldest and most established practices in Suffolk County, and the first firm in the county to specialize in elder law. That kind of longevity reflects something simple: generations of families trusting the firm to guide them through some of life's most important decisions. Lawrence's practice focuses on elder law, estate planning, Medicaid planning, and special needs planning, which is to say the intersection of legal and life planning where clarity and good guidance make all the difference. He is known throughout Long Island for his practical approach and his ability to help families make sound decisions before a crisis forces their hands. He is also a national recognition in his field. Amongst many accolades, he served as past president of the National Academy of Elder Law Attorneys, the leading professional organization for attorneys in this area. Here at Stony Brook, we're also deeply grateful for his connection, not only to present here, but his firm has also offered generous support as one of the lead corporate sponsors of the Stony Brook Film Festival, a testament to his commitment to this community. A quick note on the format: because we have so many people, we couldn't make it, obviously, we're sort of limited by technology, but Lawrence has designed tonight's program to be highly interactive. So with that in mind, just put your questions in the chat. My colleague and I are gathering together. We're going to present them to Lawrence at natural breaks in the program or when he switches subjects. So we'll present them to him. If you want, I hope everyone knows where the chat button is, but it should be down there and look like a little bubble from those of us who remember cartoons in the paper. Otherwise, it's my great pleasure to welcome Lawrence Davidow.
Hello, everyone. Yes, my name is Lawrence Davidow, and yes, I am the third generation of Davidows in my practice. Nobody was surprised to find out when I got out of law school that I got a job. But everyone was surprised to find out that I changed our firm from a general practice firm to the very first elder law firm in Suffolk County. And that's something I'm really very proud of. I'm very proud to be here today to talk to you all about elder law. And what elder law is all about is addressing the specific legal concerns that seniors may have. Seniors want to know, how can they manage their assets if they become incapacitated? How can they manage their medical decisions if they become incapacitated? Do they need a will? Is the will they have now okay? Should they be updating their wills, or should they be trying to avoid probate altogether? How do we minimize estate taxes? That's all under the elder law umbrella. But perhaps what elder law has become best known for, well, when I first started doing these speeches about 40 years ago, I used to call it the $64,000 question. But now it's the $164,000 question. It's really the $200,000 a year question. And that is, God forbid we ever had to go to a nursing home. How are we going to afford that $200,000 a year without losing our homes and everything else we worked a lifetime to acquire? So today I'm going to be talking about how to protect the family home, and probably in a larger sense, how to protect other assets as well. And my audience today, I'm assuming, is not the very wealthy. The very wealthy can afford any kind of care they want. They can afford a nursing home. They can afford to have somebody come into their home. They can afford to have 10 people come into their home and take care of them. This is not a problem for the wealthy. This is a problem for working class, middle class, upper middle class people who, if they get the wrong disease and end up in a nursing home, they lose everything they worked a lifetime to acquire, and especially their homes. So we're going to talk about how to protect your home today, and all the other assets. Now, I don't know, why do we worry about this? We have Medicare. Medicare is the greatest medical system in the world. Doesn't Medicare pay for a nursing home? What's the answer? I bet you're all saying, what? And the answer is yes. Medicare does pay for a nursing home, but don't get too excited because they only pay for about 2% of all nursing home costs in this country. But you can get Medicare to pay for some of the nursing home. First, you have to be aware in your head. What are you answering? It is the hospital. You have to be in a hospital for at least 3 days. And when you leave the hospital, you have to get into a nursing home within 30 days. And in the nursing home, you have to receive skilled care that's rehabilitative in nature. And if you pass that very strict test, Medicare will pay fully for 20 days. And then from day 21 through 100, Medicare will continue to pay, but you have a co-insurance payment of about $217 a day. If you have an Advantage plan or you have a Medigap policy, you can be covered for a full 100 days in a nursing home. If you go directly from your home into a nursing home, Medicare pays nothing. If the only care you need in the nursing home is not skilled, but just help with the activities of daily living, helping walk, eat, getting out of a chair, getting to the bathroom, Medicare pays nothing. Medicare only pays if you need skilled rehabilitative care. So what was it really designed for? It was designed for people who had to go to the hospital, they became weak, they had to go to the nursing home, they're getting rehab, they're getting back on their feet, and they're getting home. It's designed for short-term care, not long-term care. And that's the bottom line. So Medicare is not really where you turn for long-term care. Well, where do we turn then? Maybe our children will pay for it. Maybe not. Maybe not. So if the children aren't going to pay for it and you don't want to pay for it and Medicare doesn't want to pay for it, we've got to find someone else who's going to pay for it because clients don't come to me and say, I want to pay for it, show me how. They say, find a way to get someone else to pay for it. And in particular, they want to know about Medicaid. Now, Medicare and Medicaid are different, as you probably know. Medicare is federal, Medicaid is state, run by the counties. It's a welfare program. You have to be poor to be on Medicaid. And so what I'm going to teach today is how working middle class, upper middle class people can become poor to get Medicaid to pay for the care that they need. So the question then is, how poor do you have to be? Well, the right answer is dirt poor, really poor, indigent. But the real number is about $33,000. If you have more than $33,000, you're not eligible for Medicaid. By the way, that includes the value of your home. Now, if you're married, as long as your spouse is living in the house is an exempt asset. If you're not married, and this is the only asset you have, Medicaid will put a lien on your house until it's gone. Okay? Another exception, though, or a real big exception, it may be one of your biggest assets, is that all of your retirement plans are exempt from Medicaid. What do I mean by that? I mean your IRAs, your Roth IRAs, your simple IRAs, your 403Bs. If you're an employee here, your 403B, your tax sheltered annuity, your 401Ks. All of those retirement plans are exempt as an asset from Medicaid. They don't count toward the $33,000 you're allowed to have. But there's two tests to get on Medicaid. You have to be poor in assets and you have to be poor in income. So if you're going into a nursing home, Medicaid says you must first spend on the nursing home your Social Security, your pension, and the required minimum distributions on all of your retirement plans. Now, you may be saying, look, Lawrence, I've got some money. I've got some CDs. I've got a mutual fund. I have other monies, and I'll never get on Medicaid. What if you did this? What if you take your CDs and your mutual funds and all your money and you just give it to your kids? And by the way, they'll take it. But what if you did that? That day you just transferred everything to your children. The next day you're poor. Are you now eligible for Medicaid? And the answer is yes, you're immediately eligible. And the answer is no, you're not eligible. So I'm giving you two answers. Sounds kind of silly, but I'm teaching today. And what I'm teaching you is that there are actually two types of Medicaid. There's Medicaid that pays for a nursing home, institutional Medicaid, and there's Medicaid that pays for home care, something we call community Medicaid. Interestingly, if you give away all your assets today and you're poor the next day, you can get Medicaid to pay for community Medicaid. You can get Medicaid to provide aides to come into the house and help take care of you. New York is the most generous state in the country in allowing Medicaid dollars to flow to seniors who are homebound and need aides in their home. So I'm not advocating for higher taxes here in New York, I promise you, but we do get a valuable benefit from these taxes, the most generous Medicaid system in the country that allows people to stay in their homes. I can't promise it'll be 24/7. It may be 2 hours a day. It may be 8 hours a day. It may be 12 hours a day. It may be 24/7. Depends on a lot of facts and circumstances and how sick you are. But spread the word that Medicaid is available for anyone who is sick and at home. All they have to do is get the assets out of their name. They're poor the next day. And in a home care situation, we can actually save most of the income as well. Spread the word because it's one of the most important things you're going to hear tonight, that Medicaid is here to keep people home with dignity because nobody wants to go to a nursing home. However, if the nursing home is what we're facing, you have to be poor. You can't have more than $33,000. Plus, of course, I told you about the retirement plans. And pretty much all of your income is going to have to go pay for your care. So you can't just give away your assets today. There is a penalty for giving away your assets. The penalty is not a dollar amount you have to pay, but rather an amount of months that you have to wait before you're eligible for Medicaid. Now, if I were to ask a poll right now, I bet everyone would say, or most people would say, oh, it's 60 months, it's 5 years. that the penalty, if you give away your money, you're not eligible for Medicaid for 5 years. Actually, that's not true. It'll feel like 5 years in many cases, but it's not technically true. What is true is that the penalty for giving away your assets is that you're not eligible for Medicaid for 1 month for every about $15,000 you transfer out of your name. So, for example, if all you had in the world was $150,000 and you transfer that $150,000 to your children, your penalty would be 10 months. 150,000 divided by 15,000, 10. 10 months. That's would be your penalty, not 5 years, 10 months. You give away a $300,000 house, 20 months. Give away $1,500,000, 100 months. Just do the math. Now, some of you are saying, wait a minute, Lawrence, that doesn't sound right because we were told, we read, we got it in the AARP magazine, which must be true. It says that there's a 5-year waiting period. And in a way, there is, but it's a little confusing. See, there's not a 5-year penalty, but there is something called a 5-year look back. It's the Medicaid doesn't trust you law. See, when you go to Medicaid and you say, hey, I'm poor, pay for all of my care in the nursing home, they're going to go, I bet you gave everything to your kids yesterday, didn't you? And you're walking in here and you're saying you're poor and you want us to pay for it, just like you can do with home care. But they said that we know that you've been giving away all your money to your kids. You're artificially making yourselves poor, and we don't like that. So we're going to audit your books. That's what the look back is all about. And currently, we have a 5-year look back. So that means that when you apply for Medicaid, you're in the nursing home and you apply for Medicaid, they're going to audit your books, or you hire an elder law attorney to do this. It's like an IRS audit. This is important stuff. We're going to do an audit of your financial life to see if you transferred anything out of your name in the last 5 years. And if you did transfer something out of your name in the last 5 years, then there's a penalty. And the penalty is that you're not eligible for Medicaid for 1 month for every $15,000 you transfer out of your name. It's that simple. Example, all you have is $150,000. You transferred it to your kids. 3 years later, you end up in a nursing home. Are you eligible for Medicaid? Let's do the test. What's the look back? Look back is 5 years. We're going to go back 5 years. Was there a transfer caught in the last 5 years? Yes, Medicaid will say, aha, we see you transferred away $150,000 3 years ago. Penalty, penalty. What's the penalty? 10 months. When does the penalty begin? When you gave away the money or when you're in the nursing home? And the answer is when you're in the nursing home, which means that if you transferred away $150,000 within the last 5 years, you wouldn't be eligible for Medicaid for 10 months. From the first day you go to the nursing home. So for the first 10 months, you're not eligible for Medicaid. So all you have to do is get the money back from the kids. I know, so easy sometimes, but assuming that that's true, it wouldn't be a problem. So you're not eligible for 10 months. Well, that doesn't work then, because by the time the 10 months is over, that 10 months is going to cost $150,000. We didn't save any money there. All right. Would have been better though if you had given the $150,000 more than 5 years ago. Or you take everything that you want to protect, whether it's the house, the cash, the mutual fund, if you get it out of your name and 5 years go by and those transfers are beyond the look back, all those assets are protected. But I want to make something perfectly clear. I am not here today advocating that you or any other senior should be transferring away all their money to their kids or to anybody else or in any other way, because there's something more important than getting on Medicaid and protecting all this money, and that's preserving your dignity and your independence and your control over your own life. The only person on this earth that I did not give that advice to was my father. Well, he's on to me. In any way, if your goal is to protect your assets from Medicaid, or there is a certain asset you want to protect from Medicaid, you got to get it out of your name. You got to get the 5-year look back started, and your 5-year look back has to get over with. And once that 5-year look back is over, then you're in good shape. So, do we just give the money to the kids? No, I don't recommend just giving money to the kids. So, where can we give it? Or who do we give it to? And that's where this whole discussion of trust comes in. And we're going to talk about trust tonight. So, before I start talking about trust, though, I do want to talk about one other thing with Medicaid, and that there's something, if you're not married, then there's less things we can do. If you are married, by the way, I can always save money. I can save usually 35 to 50% of the money at the last minute, always. But that doesn't always satisfy everybody because people want to save everything they want to save. But in a situation where we have a married couple, and this is a man and a man, woman and woman, does not matter and should not. So we have then a couple. Let's say it's a man and a woman. And I'm going to give you an example. They have a house here let's say near the Stony Brook area here, and that house is worth, oh, who knows, $600,000. And let's say they have $300,000 in the bank. All right. Husband has a stroke and he ends up in a nursing home. By the way, in all my examples tonight, the husband is going to get sick first, and the husband is going to die first. Why do the men die first? Well, they want to. All right, I'm having fun here. In any event, so I'm going to get in trouble for that, aren't I? All right, you got to know I'm just having some fun here. I'm just trying to teach. This is a heavy subject, and if I can make you laugh a little bit along the way, I think I've done a good job. All right. So, husband has a stroke. He ends up in a nursing home. Day one, is the house a problem? No. What did I already tell you? As long as the spouse is living in the house is an exempt asset. Not a problem. All right. But they have $300,000 jointly held. Is he eligible for Medicaid? No, he's not. Why? I already told you. How much money can he have in his name? About $33,000. So he's be at least half on that joint account. So he's not eligible for Medicaid. So what we're going to do is we're going to take that house and we're going to take that 300,000 and we're going to get it out of his name. We're going to transfer everything over to the wife in this particular case. Now he thinks that Nixon's the president and he's out of it. He doesn't have the ability to sign his name, so he better have a good, durable power of attorney that has gifting in it. In other words, an agent under a power of attorney normally can't make a gift, and the agent isn't supposed to take money for themselves. But if the power of attorney says they can, they can. So you look at those powers of attorney you have and make sure it has the right language in it. So here the wife would be the power of attorney. She would take the house and all the money out of his name. She'd put it in her name. He is now poor. Is he eligible for Medicaid? Not yet, because they're going to say, wait a minute, your wife has money. Remember that in sickness and health stuff? They kind of take that stuff seriously. So they're going to say, hey, wife, your house is exempt, but you've got all this money. You should be paying for your husband. The law says she's allowed to keep 162,000 approximately, and what Medicaid will tell her to do is spend that money down on the nursing home until she's down to the 162 from 300. Maybe you're starting at 1 million. Spend it down until you're down to about 162,000, and then they'll give him Medicaid. That is the advice Medicaid will give you if you call them up. But I call it, the advice I'm going to give her is called the Nancy Reagan exception. What was she known for having said? Well, for younger people, you may not know. But she always said, just say no. And that's what the wife is going to do here. That's the advice we're going to give the wife at home, or the husband if that's the case. But here, the wife. We just say no. Say, Medicaid, I know I've got too much money, but no, I am not paying for his care. I refuse to pay for his care. And what the wife is doing here is technically called spousal refusal. This might be something the husband already knows about. In any event, she says, I refuse to pay. He gets Medicaid. Period. Medicaid has a right to sue her to support him. And they've never brought that suit in Suffolk County. They did for a while in Nassau, and then they stopped about 7 or 8 years ago. Why? Bad politics, bad policy to impoverish that other spouse. So they stopped doing it. So bottom line, if you're out there and one of you has to go to a nursing home in a couple, we transfer everything to the well spouse, We do spousal refusal every single time. We get that person on Medicaid immediately, and that's pretty much the end of the story. Okay? So you should know about that stuff. Now, moving on. Enough about Medicaid eligibility rules. Now, let's get into some planning.
Lawrence, can I ask you a couple of questions before we
Are
move
you
on?
stopping me? I'm
Sorry.
on a roll.
I know you are. I know you are. But before you move on, the subject came up, and I just want to. I think
Go
you
ahead, I'm
told
having
me,
fun. Go ahead.
but I wanna make sure that we cover them. Um, let's see. The first one, and they sort of go together. I understand IRAs are immune from Medicaid, Medicare clawback, but one's personal home is not. As a current SUNY employee, 68, carrying my own health care, which is that are both those statements true? And then you're going to be getting into the trust that can shelter assets. So that was the second part of the question.
Assuming you're not married, all your retirement plans are exempt except for the required minimum distributions. And even if you're below that 73 or 75 age where you have to start taking out minimum distributions, if you had to go to a nursing home before those ages, you have to start taking out minimum distributions. And that income, that minimum distribution, counts toward what you have to give the nursing home. The house, if you're not married, it is not exempt. Very few exceptions. Very few exceptions. It is not exempt. They will give you Medicaid because you have no cash to pay for the nursing home, but they'll put a lien on the house until the house is gone. So that's your answer. And
Perfect.
that's why people are getting these houses out of their names left and right, and why we're going to be talking tonight, with the time we have left, of how we protect the family home. Go ahead.
No, I think this one will probably come up in the future, but we just received a question about how do special needs adults fit into this overall planning? Will you be addressing that tonight, or is that something someone should reach out to you about?
Oh, they probably should reach out, like, because I don't think in the allotted time that we're going to have enough time to talk about special needs. I could do a whole seminar just on special needs, but here's a couple of things. Number one, if you have a child or grandchild with special needs who might inherit anything from you, if they are on government benefits or might be on government benefits in the future that require their poverty, they cannot inherit directly. But what we do is we have the money go into a special needs trust. The money goes into a trust, and all the money in the trust can be used to enhance and enrich the life of your loved one, but it will not affect their government benefits. So that's critical planning. But if you have a son who's a cop and he's got a bad knee and he's out on disability, that's also a disabled child who doesn't is not on government benefits. He may have some disability benefits, but nothing that requires his poverty. Um, What's cool about that is that there's an exception to the 5-year Medicaid rule, and that is you can transfer your assets at the very last second to a child with disabilities. So if you have a child who just happens to be out on disability, he's got a bum knee for whatever reason, we can transfer all the money to him at the very last second, and then he can, if he wants to, retransfer among all the kids. So there are exceptions built into the Medicaid system for people with disabilities. Hope that helps.
Great. This one will come at the end, but I think for someone sitting here thinking like this applies to me, but I haven't done a single thing of planning yet. What's the single most important step people can make?
Two things. One, open up ChatGPT and start looking into it. Seriously, start educating yourself. Not only ChatGPT, but go to seminars, read articles, find out as much as you can, but don't go down the black hole because there's so much information out there, you will get lost. But I like an educated client. So the second thing you do is you make an appointment. If it's not with me and my law firm, it's with a qualified elder law attorney who does this all day long. I want you to go to an elder law attorney because we can direct the right questions and the right answers to you, and we won't take you down the black hole. You need to know what the right thing to do for your family, not the next family. So don't listen to your brothers and sisters and your neighbors. I did this, I did that, I set up a trust, I didn't set up a trust. I think forget all that because that's looking at it through their eyes It's the right advice, maybe for them, may not be the right advice for you. But I like it when a client does a little homework before they come into the office so they can ask a higher level of questions and we can get right down to what's really important for you. So that would probably be my best advice.
Okay. And one last one before you move on. And someone sort of made it specific to themselves, but I think this is, when is it too early or too late to start thinking? Is it, is there an age? Is it a moment in life? Is
Well,
there
elder law happens to deal with estate planning through the eyes of incapacity. It's not just about death. Estate planning in general is about death, who gets what and how they're going to get it, and are the taxes and all that. But elder law brings in incapacity, which also bleeds into special needs work as well. So if you're 21 years old and you're perfectly good health, that would probably be a little too young, but not too young to have a will, to have a power of attorney where if you become incapacitated for some reason, you get into a car accident, whatever it is, you want to have somebody be able to make your financial decisions or a healthcare proxy to make your medical decisions. So at each stage in life, estate planning of some type is proper and necessary. But as you get older, then we start thinking about long-term care. Is 65 the magic age to start thinking about it? Is 60? It really depends on your goals. It depends on your health. It depends on your family history. It depends on your family, the dynamics of the relationship you have with everybody in your family. There's so many things that go into it. Certainly, when you get to that retirement age, it's certainly one of the boxes you have to check. You check in with your elder law attorney, and they may say you're too early for it. But you better have your power of attorney and your will, and oh my God, you've got some tax issues here. We want to identify those things. And it's not just talking to the elder law attorney in isolation. You really need to put a team together. You need to talk to your financial planner. You need to talk to your accountant and your elder law attorney and have a team of professionals around you to have a comprehensive answer to what life will bring. So that would be my best answer.
great? We're going to move on. I think there's some questions coming in that will be answered in the next section. The other thing I want to let everyone know is we will be sending a copy of this recording as well as Lawrence's contact information in a follow-up email. So
You didn't tell me you were going to record it. I wouldn't have said certain things.
no.
Yeah.
So we appreciate that. And off you go to, I think you
All
were.
right. So we'll go to the second part of this presentation, and that is the planning part. And clearly, I will tell you that the asset that most of my clients are trying to protect is their house. And that's why naming this whole seminar tonight, um, protecting the family home is so important because it is what 90% of my clients are interested in, especially when their other big asset is a retirement plan and it's exempt. So the house. To understand how to protect your house from Medicaid, you have to understand some basic tax law first. All right. So you bought your house for this amount. That's called your tax basis. All right. And let's say that through the years, you've owned this house for 30 plus years, you put more money into the house. Every dollar you put into it increases your basis. Now your basis is here. And then someday we're going to sell it for here. Well, the difference between what you sell it for and your basis is your profit, or what we call your capital gain. You have to understand capital gain law to understand the best way to protect your house. Now, if you sold your house right now, you probably wouldn't pay any taxes because each person gets a $250,000 capital gain exclusion on the sale of their house. And as a couple, you don't have to pay taxes on the first 500,000. So taxes are not really that important right there. Um, Now, if you die owning the house, by the way, your basis is here. It's worth this when you die. Whoever inherits it gets what is called a step up in basis. Whoever inherits it gets a step up in basis. Their basis is equal to the value of the date of death. So when they inherit the house and they sell it the next day, what's the difference? Zero. Death is the best tax shelter. There'll be no taxes on the sale. Okay? Now, but that's not what's happening right now. What happened is last weekend, your kids came over and they said, Mom, Dad, we're so concerned about you. We're so concerned that if you get sick, and end up in a nursing home, you could lose your house. So we have a great idea. We heard about this 5-year thing. Why don't you do this? Take your house and give it to us. Let us hold on to your house. And don't worry, we'll let you live there for the rest of your life. Aren't they nice? Anyway, you learned this from David out tonight. Never, ever, ever, ever put your house in your kids' names. Not outright, at least. Never put your house outright in your kids' names. I'm going to give you all the reasons tonight why you should never do that. Your basis is here, it's worth this. If you transfer the house to them while you're alive, you're giving them your basis. And maybe they hold on to it for the rest of your life because your kids are angels. They hold on to it for the rest of your life and they sell it after you're gone. When they sell it, they have the capital gain. They don't get the step up in basis. The capital gain is going to be 22% between federal and state on the profit. So you're causing a huge tax problem. Also, if you transfer the house during your lifetime, you're going to lose your star exemption, maybe your enhanced star exemption, your veterans exemption, your seniors exemptions. If you have any of those property tax exemptions or write-offs, not your house anymore, you don't get any of those. And the kids probably don't get them, so you're losing all your property tax exemptions. Your property taxes may double if you ever did that. So that's another reason not to give the house to the kids. But the best reason not to give the house to the kids, the most important reason not to give the house to the kids is, well, there could be problems. But you say, oh no, there's no problem. I love my son. I trust my son. I'll give my house to my son. He'll do the right thing. But what happens if your son dies and now your daughter-in-law owns your house? And what's worse than that, she remarries a lawyer. Now they say, sorry, grandma, you're out. And you have no recourse. Never lose control over your house, period. Never lose control of your house. Shelter is a primary need. You must have it. You must save it. Never, ever, ever put your house directly in your kids' names. So, but getting the house out of your name is good for Medicaid. So we needed a better solution. Holding on to the house is no good because Medicaid will put a lien on the house until it's gone. We need a better solution. We need a solution where we can get the house out of your name, get your 5-year look back started, get your 5-year look back over with, but keep the control of your house so that nobody can kick you out, nobody can sell the house out from under you. Keep all your property tax exemptions, your star, your enhanced star, your veterans, your senior, all your exemptions, your write-offs. You want to keep all those. Okay? Control taxes, and we still want that step up in tax basis. How do we do that? Well, there are ways. So, what tools are there in the tool shed that we can use to get the house out of your name while still keeping you in control, keeping all your tax breaks, all of the things that we want you to keep, and still get that step up in basis? There are 2 tools in the tool shed, which I'm going to discuss tonight. But understand this, I am not advocating that you should do one or the other or either. I don't know anything about you. It's only after I've talked to you for about 2 hours that we can start developing a plan that makes sense for you. But when I do a webinar like this or I do some seminar, I'm talking to 120 people here tonight. I try to make it sound like I'm talking to you directly, but I don't know anything about you. And I do not want you walking away from this webinar thinking, oh, I heard from David Howe. He said there's this life estate or a trust, or there's one of these tools in the tool shed. I'm not advocating any of them are right for you. I want you to learn more, and we should have a discussion about it because there's no one tool that's right for everybody. This is extremely individual. All right, so let's talk about the 2 tools in the tool shed to save the family home: a life estate and a trust. I'll do the life estate first. A life estate is relatively simple to understand. You're going to do a new deed to your house. You're going to transfer it probably to your children, nieces, nephews, grandchildren, whoever you're trying to protect it for. You're going to do a new deed transferring the house into their name, but on the deed, you reserve a life estate. You reserve the right to own and control the house for the rest of your life. It's your house, not theirs. They own it, but they're stuck with you because you control it while you're alive. New York State says, well, that's your house for your lifetime, so it's your property tax bill. And because it's your property tax bill, you still get all of your property tax exemptions and all the write-offs. You have the absolute right to live there for the rest of your life. Who's in control? You are. Nobody can sell it out from under you. It's your house. Nobody can kick you out. It's your house for your lifetime. Medicaid says, though, you gave it to the kids. You might have the right to live there and all that. You gave it to the kids. That starts your 5-year look back. Get your 5-year look back over with. Your house is protected from Medicaid. Pretty good. You're in control. You keep your exemptions. We still get the step up in basis as if you died owning it, wiping out all the capital gains. And then upon your death, your life estate goes poof, gone. Your kids automatically own the house. No probate, which means we didn't need to use a will to get it to the kids. We avoid probate. They own it immediately. Step up in basis. They can sell it the next day, pay nothing in capital gains. It kind of does everything. And boy, that sounds simple. Almost sounds too simple. And it's not for everybody. And here's why. This is real life. You decide, I'm going to do this. I'm going to transfer the house to my kids, reserve a life estate. 5 years later, my house is protected. I keep all these benefits. Everyone's happy until you wake up one day and you say, this house is too big for me. It's too many memories. My spouse died. My friends, they all died or they're in Florida. I'm lonely here. I can't get up the stairs anymore. My knees are killing me. And you realize that someday you got to sell the house. If you sell the house while you're alive, who gets the money? Well, the owners get the money. Who are the owners? You're an owner and your kids are owner. It's a combo. They own a future interest and you own the present interest. Think of it that way. Now, what's the percentage difference? People jump on it's 50-50 or it's 1/3, 2/3. There's no percentage like that. It changes every year. It all depends upon how old you are. You see, the older you are, the less your life expectancy, so the lower is the value or the percentage of your ownership of your life estate. So there's a difference between a 70-year-old having a life estate and a 90-year-old. A 90-year-old's life estate will be worth a lot less. And then the kids' portion would be worth a lot more. Okay. So if you did this at 70 and 10 years later at 80, you go to sell the house, the kids may get 80% of the money and 20% would go back to you. I'm not sure that's the right percentages, but you getting the concept. The 80% that goes to the kids, they have to pay capital gains tax on it because it's not their principal residence. So they don't get the 250 exclusion on that. You can only use your 250 exclusion against what you own, which is only the 20% of the life estate. So this is a disaster when it comes to capital gains tax. And the other problem is you're getting the 20%. It's like a hot potato. You don't want it. You just spent the last 10 years getting rid of it. Now it's sold and you're getting that money. You don't want that money because Medicaid can get it. So you'll give it to the kids, another 5-year look back. Or if the reason you're selling the house is because, well, you're going to a nursing home, you're going to hand that 20% to the nursing home because the kids don't want this house. They don't want to take care of it. They don't want to be a landlord in this house. They could be, but they don't want to be. So a life estate is a pretty good tool. Does everything we want, unless you want the flexibility of selling it during your lifetime. Now, you may say, I have no plans of selling my house. I didn't ask you what your plans were. I asked you, do you want the flexibility to sell the house? If you want the flexibility to sell the house and you don't want these tax and Medicaid problems, a life estate is not the right tool for you. Okay? So, and I will tell you, I don't do many life estates. I do mostly trusts, but that does not mean it's right for you because it might be perfectly good for you to do a life estate. Do you know who of my clients do the life estates? Not the people who live around here. It's the people that live in or have a house that they retired to on the North Fork, on the South Fork, somewhere where the kids want to go and keep in the family. If you're never going to sell the house, a life estate may work perfectly. But if you want the flexibility of selling the house, a life estate is probably the wrong tool in the tool shed. Then we turn to trusts. Okay, so now let's talk about trusts. Trust 101, real quick. A trust is a contract you make with somebody you trust to hold something for you. That person you trust is called the trustee. You make a contract with the trustee and you say, hey, trustee, hold my house for me, hold my assets for me. And there are two types of trusts. I'm going a little faster here now, but there are two types of trust. The contract that I talked about can be one of two types. One where you can break the contract anytime you want, or one where the contract is set in stone. If you can break the contract, get rid of the trust, and get your property back from the trustee, that's called a revocable trust. And when you set up this trust and you sign it with the trustee and you give them your house and maybe other assets to hold, and the trust agreement says that you can't break the contract and you can't get it back, that's called an irrevocable trust. That's simple. Now, I could do a whole seminar just on revocable trusts. I will tell you that they're very popular. I write a lot of them. They're not for Medicaid planning. It's this simple. If you set up a trust, a revocable trust, and you take your house and other assets, everything you want to protect from Medicaid, and you transfer the ownership of those assets into the name of your revocable trust, but you can revoke it and get it back whenever you want. If you can get it back, Medicaid can get it. It does not work. The 5-year look back never starts. So revocable trusts do nothing to protect your assets from Medicaid. Maybe you did all your own estate planning already and you did a revocable trust. You did nothing to protect your assets from Medicaid. The reason that people create revocable trusts is to avoid probate. Avoiding probate means avoiding using the will. A will is worthless until you march it into court and probate it. The judge wants to know everything that's going on. It takes 6 months to a year, it takes a long time, it's more expensive. People don't want to do that. They want to streamline it, they want it efficient, they want their kids to immediately get everything, so they set up revocable trust to avoid the probate court, avoid probate. Great plan, as long as your goal is not to protect your assets from Medicaid. If your plan is to protect your assets from Medicaid, forget the revocable trust, talk about an irrevocable trust. And that is you take your house and whatever else you're trying to protect, you give it to the trustee to hold for you. It's not theirs. They can't touch it. They can't, their creditors can't get it. Their spouses can't get it. If they die, their estate doesn't get it. All they're doing is they're the hired help that we're not going to pay. So this trustee of an irrevocable trust will hold your house for you. The trust says it's irrevocable, you can't break it, and you can't get the house and money back in your name. If you can get it, Medicaid can get it. Has to stay in the trust. But we make you happy by all the things that really matter to you. The trust agreement says you have the absolute right to live in the house for the rest of your life. Nobody can kick you out. Nobody can sell it out from under you. It's your house. If you give your consent, then the trustee can sell the house. The trust will sell the house. The trust will get the money. The trust can invest that money. You still can't get the money back, but the trust could buy you another house. This house is getting too big. You want the 55 and older community condo? No problem. Trust sells this house, buys the other one. No new 5-year look back. No penalties. It just once the assets are in the trust, they can be reinvested in anything, including another house. Okay. All right. So with a revocable trust, you could be the trustee of your own trust. With an irrevocable trust, you can't be the trustee. You need to pick someone else as the trustee. Usually, you'd pick one or more of your children to be the trustee. And if you can't trust your kids to be the trustee, why are you trying to save the house and money for them in the first place? Okay, so probably you're going to pick your kids as trustee. Certainly you would because your kids are all angels. All right, I must be talking about somebody else that's not. So you can create an irrevocable trust. You can put your house and other assets in there. Now, 5 years later, your assets are protected in that trust. You keep the control, nobody kick you out, you're in control. You keep all your property tax exemptions. You still get that step up in tax basis at death. And upon your death, the trust might terminate and the assets in the trust will go out to your kids, avoiding probate. So that pretty much in a nutshell is how you protect the family home. Now, is there a lot more on this? Yes. Could I speak for another 3 hours? You bet I can. And I'd love to at some point. But they gave me a time limit, and I'm already over it. So that is pretty much the story of how you protect the family home. These trusts can also protect CDs and money markets and annuities and anything else you want to protect. Doesn't have to be one. You may have two houses. You may have a separate lot up in Nevada that you haven't seen in 50 years that somebody sold you. We may want to do something with that too. Yeah, whatever you have can go into these irrevocable trusts. Everything in there, including your stock, would get a step up in tax basis. It's pretty elegant. It's not for everybody. So everything I told you here today is not for everybody. Every plan is different. Every individual is different. Dynamics are different. So um, that's kind of the story. I want you to know I feel so privileged to be here today. I feel so privileged to be invited to be part of the Stony Brook family. This is an amazing institution. Thank God we have it here in our community. It is the biggest employer, and it's a center for culture, for education, for communication, for community, and it's precious to us. So, Sean asked you to give. I'm going to give a plug too. Give to Stony Brook, all right? Because it's important to us all. It's all important to we have to stick together as community, and this is really one of the core parts of our community. And he mentioned before, I'm also a proud sponsor this year for the Stony Brook Film Festival. I'm going to be there pretty much every night, probably with a sore butt on those chairs, but I'm going to be there because it is amazing to be part of a community event. You go there every night and you see some of the same people, and you're going through this whole uh, 9 day event together. It's just such a community thing, and it's really wonderful. If you notice me there, come over and say hello and give me pointers on maybe how I can improve this. Okay. Thank you very much. It was a pleasure talking to you all tonight, and I welcome your questions.
Okay, we have a few.
Uh-oh.
I think you've answered some of them in terms of any assets that you want to protect can go into the trust. Is that sort of a good summary there that you sort of came to at the end?
Everything we want to protect that needs protection could pretty much go into the trust.
Okay.
Whether it's appropriate in a particular case, we have to decide. And remember, one of your biggest assets would never go in the trust. IRAs, 401ks, 403bs, they're exempt, so we wouldn't need to. But even if you tried, it wouldn't work because when you move a retirement plan into an irrevocable trust, it would trigger the income tax and all the money. So that is an asset we would not even look at to put into a trust.
Okay.
And we don't need to.
So would you, and someone's asking a question about, would you need a separate account to pay house expenses? Can the house expenses come out of the trust itself?
Yeah,
How?
it's a good question. The way I designed the trust, in order for you to keep your star exemption, I make it so that you are responsible for all the trust expenses. Strike that. That's not what I meant. You are responsible for the household expenses. So you still have to pay your property taxes, your cable bill, the maintenance, your insurance, everything to do with the house you have to pay personally. The trust is designed that it cannot pay your bills. As soon as the trust pays your bills, the trust doesn't work anymore. If the trust uses $1 in it to pay a bill of yours, the trust doesn't work anymore. You have to understand the concept here. The concept is you're showing everybody that you don't own these things. You gave it away so that you're poor, so that Medicaid will pay for you. You can't also, on the sly, have the money in the trust be used to pay your bills. Having said that, that doesn't mean that money is stuck in this trust forever until your death. I do put a clause in the trust that says that the trustee, perhaps with your consent, can take money out of the trust and give it to your kids, who are the ultimate beneficiaries of the trust. And once the kids get the money, well, they can send you a beautiful postcard from Tahiti or do anything that they want with that money. And if they want to help their parents, they can, but there's absolutely no obligation for them to do so or expectation. Okay.
Great. So along those lines, do you have to pay the trustee of the trust?
The answer is if you pick your children, take pleasure in not paying them. You do not, normally you're picking friends and relatives, you don't pay them. If you want to, you can, but in pretty much every Medicaid trust I've ever created, we don't pay the kids to do it. Now, if you picked a corporate trustee, you had an attorney, an accountant, or a bank, someone, a professional trustee, they're going to require payment. But in these type of trusts, I never see that.
Okay. What about assets that you have in a joint name? Can they go into the trust and still get the stepped up basis, or does it matter whether you're a married couple using a trust together or
Yeah, normally what I do with a married couple is I have one trust. You don't need two trusts. One joint irrevocable trust. The house jointly will be transferred into the trust. Interestingly, you get a step up in tax basis on half at the first death and a step up in tax basis on the other half at the second death. Works fine.
okay? A few more sort of more specific ones, but can you address how all this planning addressed the New York State cliff, and if you're over, how you should handle the overage? Um,
That's a seminar for another day. It has nothing to do with the topic here, but I will tell you this. If what this questioner is asking about is the New York Cliff is that New York State has a $7.35 million estate tax exemption. So if you have less than 7.53 million, you have no taxes. But if you have 5% more than that at the time of your death, you lose your exemption and you're taxed on the first dollar. That's a huge tax. So if you go 5% above 7.35 million, which is about 7.7 and change, if you have more than that, you have no exemption, you're taxed on the entire thing. That's what they mean by falling over the cliff. That is really not an elder law issue. People with $7.35 million are not usually too concerned about how they're going to pay for their nursing home. In theory, we could. If you have 7.35 million, I could put it into an irrevocable trust and 5 years later you could be protected. But that's not the way people with that kind of money really think. They have plenty of money, they'll pay for their care out of their income. There is no threat to their principal. If you have money that's going to be in greater than the cliff, you need traditional estate tax planning, and that's just a topic for another day. We don't really have time for that today, but I'm happy to talk to you about it. And it's certainly work we do in our firm every day.
Sure. There's one question that I know from past experience that I can answer for someone. It says, "What's the average cost to write an irrevocable trust?" And I know my favorite attorneys all like to say, "It depends." Is that sort of
It
true?
depends, but don't let me fool you. It's probably in the nine to $10,000 range, give or take.
Okay.
I'm
Great.
not holding back here tonight.
I like it. I like it.
All right, which is about 2 weeks in a nursing home.
That's an amazing sort of way to think about it. A couple of last ones. This one's sort of an interesting conundrum. Can you borrow against the equity of a home and pour that borrowed money into the allowable threshold of a Roth IRA over several years? So
Not a topic for that's not a topic
that's
for tonight.
okay. Keep it
Let's
on
stay
task.
let's
Okay.
stay on topic.
Sure. And then this one is the last one that we really have is what if the spouse passes away after the trust is made? What effects does that have on the overall planning?
So a couple transfers assets into a trust for Medicaid purposes, and one spouse dies.
I think that's the question,
Then
yes.
the 5 year look back would continue or perhaps be over for the other spouse, and everything's still protected. And we got a 50% step up in tax basis at the first death. So it just continues.
Great. We're going to send out, there's a couple of questions about breaking into trust and things, but I think that's sort of outside the bounds. So we'll, like I said, we'll send Lawrence's contact information out. And if you have specific questions like that, then you can direct them to him. All right. Otherwise, we really appreciate it tonight. Like really, oops, I gotta get back on camera since I'm not in my Q&A mode anymore. But really, Lawrence, that was one of the most direct and understandable presentations on this topic that I've ever heard. So I really appreciate you and your time and the way
My
that
pleasure. And
um,
I specifically tried to stay on time tonight so that we can all get to the Knick game. Go Knicks.
That's what my colleague over here is beating me over the head with. Shut up, Sean, and get moving. So we will the two last few things that we have. One, as a member of the Legacy Society, we have these mugs that we hand out to all members, only to them and them. But Lawrence, for your work tonight, we really want to recognize you as an honorary member, so we'll be giving you one of those.
All
And
right.
and again, we want to remind everyone of the healthy aging webinar seminar, sorry, in person that we're having on Friday. As I said, reach out to gift.planning@stonybrook.edu if you need more information or you missed the link that my colleague shared earlier. Also, if you have any other questions about this, giving the Stony Brook or other questions, or even questions, if you don't get our email in a timely manner and you still want to reach out to Lawrence, let us know. You can reach out to that and we'll do it. For anyone else, we appreciate you being here and we want to, wish you all a wonderful evening. Safe travels home if that means closing your laptop and enjoying the Knick game. As a New Englander, I'm joining along and honorarily joining my wife. I know they didn't beat the Celtics this year, so I can, in good conscience root for them. But best of luck, everyone. Thank you, Lawrence, again, and we will see you all soon.
My pleasure. Thanks, everybody. Take care.